PVL3701 Property Law Study Unit 10. In this study unit, we discuss two types of limited real rights, servitudes and restrictive conditions. We discuss the vesting, definition, nature, and classification of servitudes in general. We also distinguish between land, predial, servitudes, and personal servitudes. We further discuss the termination of servitudes, the relationship between the servitude holder and the owner of the burdened thing, remedies, and public servitudes. Restrictive conditions and the remedies available in the case of non-compliance with condition of title are also dealt with. Okay, and then there's an example. X and Y are co-owners of the farm Waterford and of their car. The farm implements were purchased from the cooperative C in terms of a credit agreement. The cooperative reserved ownership of the farm implements until the final installment had been paid. X and Y owe the land bank 100,000 rand, and to secure this debt, L has a mortgage over the farm. X's mother, M, has a right of habitation, personal servitude over the old homestead where she lives at present. S has a right of way, personal or land servitude, and drives over his grandparents' farm, Pulang, every day to inspect his cattle on Waterford. Number 1. Introduction. We remind you that in this module you encounter different types of real relationships. So far you have studied ownership, which is a real right, and other real relationships, that is possession and holdership. This study unit deals with limited real rights. These are real rights which a person has over another person's thing. Ownership is a real right with regard to one's own thing, while a limited real right is a real right with regard to a thing belonging to another person. In principle, ownership is unlimited, whereas limited real rights are limited. The following types of limited real rights can be distinguished: servitudes, restrictive conditions, and real security rights. We discuss servitudes and real security rights in this study unit. Because of their peculiar nature, sui generis nature, mineral rights and the rights of lessees, tenants, will be discussed in study unit 12. And then there's diagram 12 of limited real rights, which you can study on your own time. And then they say, in the example above, we can identify the following real rights. Number 1, X and Y have co-ownership, real rights over own thing, of the farm Waterford and their car. Secondly, C reserved ownership of the farm implements, real rights over one's own thing, a specific form of ownership to secure a debt which, on insolvency, is converted into a tacit hypothec, a specific form of real security. Thirdly, L has a mortgage, a limited real right over another person's thing, a real security right, over X and Y's farm. Fourthly, M has a right of habitation, a limited real right over another person's thing, as a personal servitude, over the old homestead. And lastly, S has a right of way, a limited real right over another person's thing, personal or land predial servitude, to drive over his grandparents' Q and R's farm Pulang. And then there's just an activity which you can study on your own time, and then we continue on to servitudes. In this study unit, the nature of servitudes is discussed extensively. The classification of servitudes, the different types of servitudes, the establishment of servitudes, the characteristics of servitudes, and the protection and termination of servitudes are dealt with in detail. Number 1, Introduction. You should note that a limited real right of servitude is established only after it was vested in the prescribed way, that is, by registration. This means that the party must agree on the creation of a servitude, and this agreement must be registered. Until registration has taken place, the future servitude holder merely has a personal right, creditor's right or claim, against the owner. Only on registration does the holder acquire a limited real right that is enforceable against the owner and successors in title. In exceptional cases, an agreement creating the servitude can operate against third parties. As a rule, before registration has taken place, the agreement creating the servitude agreement, cannot be enforced against third parties. In the exceptional case where a third person has knowledge of the existence of the servitude agreement, it may be enforced against him or her. This is a consequence of the application of the Doctrine of Notice. Make sure that you understand the operation of the Doctrine of Notice. And then we can study the vesting of servitudes there in diagram 13 on your own time. In studying this section, you must ensure that you understand the distinction between a personal right, that is, a creditor's right, a personal servitude, that is, a limited real right, and a land, real or preadal servitude, that is, a limited real right. Number 2, definition. A servitude can be defined as a limited real right to another person's thing. It confers specific entitlements of use and enjoyment on the holder who enjoys these entitlements as owner of a particular piece of land, in the case of land, or in his or her personal capacity, in the case of a personal servitude. In this study manual, we use the term land servitude to denote a preadal or real servitude. We regard this term as more appropriate as it eliminates confusion in the term real servitude, in that the term real servitude may lead students to think that a personal servitude is not a limited real right. Furthermore, the term land servitude clearly indicates that in this case we are dealing with two pieces of land, that is, immovable things. The owner's entitlements to his or her thing are limited in favor of another person, either in his or her capacity as the owner of a piece of land, a land servitude, or in his or her personal capacity, that is, a personal servitude. The servitude holder acquires a limited real right to exercise these entitlements when he or she complies with the necessary requirements. And then there's just a small activity. Number 3, establishment. Number 3.1, source. Servitudes may arise from one of the following legal facts: an agreement, legislation, court order, or prescription. Only an owner may grant a servitude over his or her property. In the case of more than one owner, all the co-owners must cooperate, and where there is a bond on the property, the bondholder must consent to the granting of the servitude. An agreement, even if it has been notarially executed or a testamentary bequeathed, will not establish a servitude, but merely creates a personal right, that is, a creditor's right, to have the servitude registered. A negative servitude cannot be acquired by prescription just because the owner of land has not exercised all his or her entitlements of ownership. Acquisition of the servitude in this case requires a positive act preventing the owner from exercising his or her rights. Number 3.2, vesting. One should differentiate between movable and immovable things. A servitude over movables vests once the movables are delivered. In the case of immovables, land, a servitude vests once it is registered in the deeds registry. The only exception to this rule are the establishment of a servitude by prescription, legislation, or a court order. Only personal servitudes may vest over movables, for example, a usufruct over a flock of sheep. Both personal and land servitudes may vest over immovables, for example, a usufruct over a farm or a right-of-way over a farm. A servitude over immovable things is established or vests on registration of a number 1, reservation in a grant by the state. Number 2, reservation by a transferor in deed of transfer. And number 3, a notarial deed. The registration of the servitude is endorsed against the title deeds of the dominant and servient tenements in the case of land servitudes. The registration of a servitude which is established by statute, prescription, or a court order serves merely as a correction of the deeds registry records. And then there's a very small activity. Number 3.3, Doctrine of Notice. And then there's an example based on the facts in Grant versus Stone Street, 1968. S has entered into an agreement with Q and R, in terms of which they have given him the right to use the road over their farm to Waterford. This agreement is in writing but not registered. Q and R sell the farm, and the new owner, who knows about the servitude agreement, refuses to allow S to use the road. A servitude agreement creates a personal right, that is, a creditor's right, to have the servitude registered. The limited real right is created only on registration. The registration of a servitude serves as notice to the world at large of the existence of the limited real right. However, someone who acquires ownership of the servient tenement, knowing that there is an unregistered servitude agreement in respect of that land, is bound to respect the existence of the servitude agreement. In terms of the doctrine of notice, such new owner who has knowledge of the servitude agreement is bound to register the servitude. Someone who acquires land without paying for it, that is a successor titulo lucrativo, for example, as a gift or in terms of a will, or at a judicial auction, is bound to respect the servitude agreement even if that person does not know of the servitude agreement. And then you can just study permission, personal right, personal servitude, and land servitude distinguished in diagram 14, as well as an extensive activity which you can do on your own time. Then we continue here on number 4, nature and classification. You must always bear in mind that all servitudes are limited real rights. Servitudes are divided into personal servitudes, that is, Servitudes personarum, and land servitudes, predial or real servitudes, Servitudes prediorum. Although they have certain features in common and are established in the same way, there are fundamental differences between the two. A servitude subtracts from the owner's ownership, and because there is a rebuttable presumption that ownership should be unencumbered and free from servitudes, servitudes are construed in such a way as to give the least onerous interpretation to them. If there is some doubts as to whether a servitude is a personal or a land servitude, it will be construed as personal servitude, since personal servitudes have a limited duration and are therefore less onerous than land servitudes. Number 4.1. Significant differences between land and personal servitudes. Number 1. Land servitudes are created in favor of a piece of land, while personal servitudes benefit someone in his or her personal capacity. Number 2. Land servitudes last indefinitely, in principle, whilst personal servitudes can be granted only for a specific period, or for the holder's lifetime, or, if not granted for a specific period, in the case of legal persons, for 100 years. Number 3. Land servitudes can be established over immovable things only. Personal servitudes may be established over movables, for example, over money or a flock of sheep or a herd of cattle, and immovables, land. Number 4. Land servitudes are alienated together with the land. Personal servitudes are inseparably attached to the holder's person and are in no way transferable. Number 4.2. Significant common characteristics of personal and land servitudes. Number 1. Both are limited real rights. Number 2. The maxim that no one can establish a servitude over his or her own thing, nulli res sua servit, applies to both land and personal servitudes. And lastly, the maxim that a servitude cannot be established over another servitude, that is, servitus servitutis non esse potest, applies to both types of servitudes. Please forgive my Latin. And then there's just another activity that you can study on your own time. Number 5. Land or predial servitudes. Number 5.1. The definition. A land servitude can be defined as a limited real right to the land of another, a servient tenement, which confers on the owner of the dominant tenement in principle permanent defined entitlements to use and enjoyment with regard to the servient tenement. The tenement in favor of which the servitude is established is referred to as the dominant tenement, praedium dominans, and the tenement subject to the servitude is referred to as the servient tenement, praedium serviens. Number 5.2, characteristics. Number 5.2.1, general. South African law does not recognize a limited or closed number, that is, numerous clauses of land servitudes. However, a right must comply with certain requirements before it will be recognized as a land servitude. The reason for this is that if land could easily be burdened by all kinds of servitudes, commercial traffic in land would be affected detrimentally. Number 5.2.2, requirements for validity. Number 5.2.2.1, two or more properties. There must be at least two properties, a dominant and a servient tenement, belonging to different owners. If there is no dominant tenement, the servitude may at the most be a personal servitude. If the two properties have a single owner, the maxim that no one can have a servitude over his or her own thing, that is, nulli res sua servit, applies. If these requirements have been met, but the owner of one of the tenements, whether the dominant or the servient tenement, subsequently becomes the owner of the other tenement as well, the same maxim applies and the servitude terminates through merger. Number 5.2.2.2, benefit, utilitas. A land servitude must enhance the use and enjoyment of the dominant tenement. It must be to the use and benefit of the dominant tenement, and not serve merely to satisfy the owner's whims and fancies. There is authority for the view that the advantage conferred by the servitude need not be economic, but may also be merely aesthetic. Number 5.2.2.3, proximity, vicinitas. The tenement must be situated in relation to another, in such a way that the effective exercise of the servitude to the benefit of the dominant tenement is possible. The tenement need not be adjacent. Even where two tenements do share a common boundary, the physical character of the environment may be such that the one tenement could not possibly enhance the use or enjoyment of the other. For example, if a water source were separated from a catchment dam on a neighboring farm by, say, a mountain range, a servitude of aqueduct would hardly be a practicable proposition. This requirement is closely related to the benefit, utilitas requirement. Number 5.2.2.4, permanency, perpetua causa. The servitude must have a degree of permanency. A land servitude cannot be established for a single, non-recurrent exercise of the right conferred. The servient tenement must be able to satisfy the needs of the dominant tenement on a continual basis. Number 5.2.2.5, passivity. Servitus in faciendo consistere non potest. A servitude cannot impose a duty on the owner of the servient tenement to perform a positive act. It can only require that he or she endures a particular activity or that he or she refrains from a particular act. He or she cannot be obliged to do something. In Roman law, there were certain exceptions to this so-called passivity principle, namely the servitude for the support of a buttress. Servitus honoris ferendi. For example, where a beam is supported by a wall on the servient tenement. In this case, the wall must be maintained by the owner of the servient tenement. There is also the servitude of not building higher, servitus altius non tolendi. The latter is not really an exception to the principle, since it does not expect the owner of the servient tenement to do something, but to refrain from doing something. This principle was recognized as a requirement for validity in Squadhelm versus Houman, 1947, but in Van der Merwe versus Wiese, 1948, doubt was cast on the view that the passivity principle is an absolute requirement for land servitudes. The point of departure in the first decision would seem to be more acceptable. The Squadhelm case was subsequently confirmed in Low Water Properties Proprietary Limited versus Walu Sand, 1999. Number 5.2.2.6, Indivisibility. A land servitude relates to the entire dominant tenement and burdens the whole of the servient tenement. The divisibility of a servitude must be distinguished from the physical subdivision of the land to which the servitude implies. The servitude remains vested in each subdivision of the original dominant tenement, insofar as the subdivision benefits thereby, and provided that the burden on the servient tenement is not increased. Mere subdivision does not entail a burdening of the servient tenement. A person relying on this must indicate why the subdivision amounts to a burdening of his or her possession as owner. The same applies to the subdivision of a servient tenement, except where the servitude is demarcated and relates to a particular portion of the tenement only, such as a right of way. Those subdivisions which are not crossed by the right of way, for example a road, are exempted from the servitude in the case of subdivision. For example, a servitude of way was established over Pelong in favor of Highlands. Highlands is subsequently subdivided so that the subdivisions are transferred to X, Y, and Z. Notwithstanding the principle that the owner of the dominant tenement may not increase the burden on the servient tenement, X, Y, and Z, as owners of the respective subdivisions of Highlands, may nevertheless each exercise the servitude of way. The same applies if the servient tenement Pulang is subdivided, unless the right of way has been determined with reference to a specific route. And then there's just a small activity. Number 5.2.3, Classification. Land servitudes are divided into rural servitudes, that is, Servitudes Praediorum Rusticorum, and urban servitudes, that is, Servitudes Praediorum Urbanorum. While rural servitudes usually relate to rural land and urban servitudes to urban land, the distinction is actually to be found in the purpose for which the land is designated. For example, for agricultural use or else for residential, commercial, or industrial use. Although the proximity vicinitas principle is applied more strictly in the case of rural servitudes than for urban servitudes, the significance of the distinction between the two kinds of land servitudes has become less important. Both rural and urban servitudes are usually positive. They create entitlements to perform an act on the servient tenement, for example, to walk over it, eis facendi. But in the case of urban servitudes, certain negative servitudes also occur. In these cases, the servitude holder acquires entitlements to prohibit the performance of certain activities on the servient tenement. For example, the entitlement to prohibit the owner of the servient tenement from building higher, that is, servitus altius non tolendi. The distinction between positive and negative servitudes has greater practical significance, for example, in the case of the termination of a servitude by prescription. The non-use of a negative servitude cannot lead to its termination by prescription. There is no closed category of land servitudes. As long as these servitudes comply with the requirements for validity, they need not conform to any particular mold. Number 5.2.3.1, Rural Servitudes. Important forms of rural land servitudes are: Number 1, rights of way, for example, the right to walk or drive over the servient tenement. Secondly, rights to water, for example, the right to draw or lead water from the servient tenement. Number 3, rights to grazing, for example, the right to graze animals on the servient tenement. And fourthly, outspan, for example, the right to rest, graze, and water animals on the servient tenements. Circumstances may sometimes necessitate a right of way, namely a via necessitatis, a way of necessity, over a servient tenement. The owner of a piece of land which is without access to a public road can obtain a right of way over another's land, so as to gain such access. Two situations can be distinguished. A. Temporary emergency way of necessity, where no compensation is paid. And B. A permanent way of necessity, where compensation is paid to the owner of the servient tenement. A way of necessity can be acquired either by an agreement and registration or by a court order. If the way of necessity is granted in terms of a court order, the latter merely confirms the existence of the servitude. In Van Rensburg versus Coetzee, 1979, the underlying principles of a way of necessity was indicated as being that it must follow the shortest route and cause the owner of the servient tenement the least possible inconvenience. The following guidelines are laid down by the court for a successful application for a permanent way of necessity. Number 1. The particulars of the claim must allege the particular necessity. For example, that the defendant's land is situated between the applicant's land and the nearest public road. Number 2. The nature of the way of necessity must be stated. For example, that a farmer will be able to exercise his or her farming activities reasonably. Number 3. The nature of the terrain over which the way of necessity will run must be determined. For example, that the terrain is such to accommodate the way of necessity. Number 4. A particular route must be determined as being most suitable. Number 5. The width of the road must be stated. And number 6. An amount of compensation should be offered, which must be reasonable, taking into account factors such as the advantage gained by the applicant. And this was confirmed in Sanders N.O. versus Edwards N.O. 2003. And then there's just a small activity. And then we go on to number 5.2.3.2, Urban Servitudes. Important forms of urban servitudes are those relating to, number 1, light and view. For example, a servitude of letting light in. Servitus luminis immittendi. And a servitude of not building higher. Servitus altius non tolendi. A negative servitude. And number 2, rain and drainage. For example, a servitude to have the water dripping from one's eaves onto the neighbor's building or land. Servitus stilicity avertendi, and a servitude of water streaming, not dripping, onto neighbor's land. Servitus fluminis recipiendi. And number 3, walls and structures. For example, a servitude by which the owner of the servient tenement is obliged to support a buttress. Servitus honoris ferendi, an exception to the passivity principle, and where no such obligation exists, but the servitude holder is entitled to insert a beam in his or her neighbor's property. Servitus techni immittendi. Then small activity, and then number 6, personal servitudes. Number 6.1, definition. A personal servitude can be defined as a limited real right, granting the servitude holder specific entitlements of use and enjoyment with regard to the movable or immovable thing of another in his or her personal capacity for a specific period of time, or for his or her lifetime, or in the case of a legal person, for a maximum of 100 years. This servitude is of highly personal nature, in the sense that it is inseparably attached to the person of the holder, and cannot last longer than his or her lifetime. In the case of a legal person, the duration is 100 years if no period has been stipulated. A personal servitude cannot be transferred in any way, and it lapses on the holder's death. A servitude holder may, however, abandon his or her servitude. A personal servitude may be created over movable or immovable things. Unlike Roman law, modern South African law does not have a closed category of personal servitudes. Familiar forms of personal servitudes are usufructus, uses, and dwelling, Habitation. Personal servitudes may also take the external form of land servitudes. These, the so-called irregular servitudes, servitudes irregulares. Such servitudes have the substance of recognized land servitudes, but are constituted not in favor of a dominant tenement, but in favor of a specific person in his or her personal capacity. For example, a right of way or a right to lead water granted in favor of a particular person. And then you can just study diagram 15 on the distinction between personal and land servitudes. A personal servitude here is the road over Palang, the servient tenement, registered in favor of S in his personal capacity. Only S can exercise the servitude. And the land servitude is the road over Palang, the servient tenement, registered in favor of Highlands, the dominant tenement. Any owner of Highlands can exercise the servitude. And then number 6.2, specific personal servitudes. Number 6.2.1, usufruct. Number 6.2.1.1, introduction. A usufruct can be defined as a personal servitude conferring a limited real right on a person. The usufructory to use another person's thing and to reap its fruits, with the duty to return the thing to the owner with the preservation of its substance. Salva re substantia. Preservation of its substance means that after termination of the usufruct, for example, in the case of a usufruct of a farm with a certain number of trees and cattle on it, the farm must be restored to the owner with the same number of trees and cattle, not necessarily the same trees and cattle. Usufruct is the most common personal servitude and is often reserved in a will to benefit a person nominated by the testator, such as his wife or her husband, or reserved on transfer of land, in favor of the transferor. For example, a father may transfer the land to his children and reserve a usufruct for himself and his wife. The servient thing may be either movable, money or a flock of sheep, or immovable. It may be a singular thing such as a farm, or a collection of things such as a flock of sheep, a library, or an estate. However, it cannot be a consumable thing, because if a thing is consumed, it cannot be returned to the owner in the same condition. Number 6.2.1.2, Rights of Usufructory. The usufructory is entitled to control, use, and enjoy the servient thing. He or she may also enjoy the fruits, both natural and civil. First, natural fruits, fructus naturalis. In the case of land, are vegetables, flowers, harvests, plantations planted for the purpose of cutting, that is silva cordua, and in the case of animals, their produce and the service they render, for example, milk, wool, manure, meat, and their offspring. And secondly, civil fruits, fructus civilis, include interest, dividends, and rentals. The usufructory becomes the owner of the fruits when they are gathered. Fruits have not yet been gathered when the usufruct terminates do not accrue to the usufructory or his or her heirs. Civil fruits become the usufructory's property at the time when they are due. Should the usufruct terminate before that date, provision is made pro rata for the period during which the usufruct existed. Although brushwood and shrubbery are not considered fruits, they may be used by the usufructory for household and agricultural purposes. Trees, even uprooted trees, may be used only to benefit the land. Trees planted for cutting may be cut, subject to the principle that ensures preservation of the thing. Salva re substantia. Owing to the highly personal nature of the servitude, a usufructory cannot be alienated, nor can the usufructory alienate the servient thing. He or she may, however, let his or her entitlement to use the object of the usufruct. The entitlement acquired in this way by the third party is not a limited real right against the owner, but a personal right, that is, a claim or creditor's right, against the usufructory, who retains the limited real right against the owner. Number 6.2.1.3 Duties of Usufructuary. The usufructuary is obliged to use the servient thing in a reasonable manner for the purpose for which it was intended. He or she should have the attitude of a reasonable man or person, bonus paterfamilias, and restore the thing to the owner in the condition in which it was when he or she took control of the thing. He or she may not exhaust or destroy the thing, or allow it to lose value or change character. He or she may, however, develop or exploit the thing in a new way only if this is reasonable and sensible in the circumstances. For example, the usufructuary may convert grazing land into arable land. The usufructuary is obliged to give security for restoration of the thing in the condition in which it was when he or she took control of it. A failure to do so will deprive him or her of the right to exercise the servitude. There are, however, certain exceptions to this rule, and the usufructuary need not give security where, number 1, parents have left with their property to their children under a will, reserving a usufruct for themselves. Number 2, an owner, on alienating his or her property, reserves a usufruct for him or herself. Number 3, the usufructuary has been explicitly exempted from giving security. Or number 4, the state, fiscus, is the usufructuary. The usufructuary is responsible for the expenses involved in the ordinary maintenance of the thing in the condition in which he or she received it. Extraordinary expenses are borne by the owner. The usufructuary is not held responsible for normal wear or tear or for improvements where the thing is destroyed, though no fault of his or her own. However, he or she must maintain the number of livestock in a herd or flock of the young that are born, or by buying new stock, and he or she must replace trees that die in an orchard. Ordinary taxes on the servient thing are paid by the usufructuary, but not premiums on a fire insurance policy or interest on a bond taken out by the owner. These are regarded as extraordinary expenses for which the owner is responsible. The usufructuary would only be responsible for these expenses if he or she had agreed to assume this responsibility. If the owner fails to pay these, the usufructuary may pay them and recover the extraordinary expenses from the owner if the latter has consented to the incurring of such expenses. If not, the usufructuary will have to base his or her claim on the principles of unauthorized administration of another person's affairs or another's affairs. Negotiorum gestio. And then there's a small activity. Number 6.2.2 Use or usus. Use is a less comprehensive personal servitude than usufruct. It is a personal servitude conferring on the holder a limited real right to use the property of another for his or her own needs and those of his or her household, provided the character of the thing is preserved. The user may only use such property to provide for his or her daily needs and those of his or her household, which includes employees and guests. For this purpose, he or she may gather only fresh products such as vegetables, milk, and eggs. The rest are due to the owner. The user may, of course, also draw water and collect firewood for personal use. By the very nature of his or her right, the user cannot alienate the property or his or her real right to it. Unlike usufruct, use does not entitle the holder of the right to let the thing. Note, however, that even in the case of a usufruct, the third person who has acquired an entitlement from the usufructuary does not acquire a limited real right against the owner, but merely a personal right, a creditor's right or claim, against the usufructuary. In the case of use, however, not even the latter is possible. And then there's a small activity. Number 6.2.3 Dwelling or Habitation. And then there's an example. M, X's mother, has a right of habitation over the old homestead on the farm where she lives at present. This right is registered in the deeds registry against the title deed of Waterford. This servitude is less comprehensive than a servitude of use. Dwelling is a personal servitude conferring a limited real right on a holder to occupy another's house, with retention of the character of the thing. The servitude holder may occupy the house with his or her household. He or she may not alienate his or her real rights, nor can he or she alienate the property. Unlike the user, he or she may let the house, but he or she does not have the right to use the fruits of the land for his or her own daily needs. And then there's a small activity as well as diagram 16, which discusses entitlements of holders of personal servitudes. And then number 7, termination of servitudes. A servitude is terminated. Number 1, upon the expiry of the period for which it was established or the fulfillment of a resolutive condition, and specifically in the case of a personal servitude by the death of the holder or where the holder is a legal person after 100 years, if no time period was fixed by. Number 2, agreement. Number 3, prescription. Number 4, expropriation. Number 5, renunciation, abandonment. Or number 6, merger. Number 7, the impossibility of exercising the right has a consequence of a permanent change in the condition of the dominant or servient tenement. For example, in the case of a servitude to draw water where the well was completely dried up. In Kitson versus Jim Speed Enterprises 2009, it was decided that a right of habitation does not extinguish when the building it pertains to is destroyed. The court held that the right will revive when the building is replaced or repaired. The owner must allow the holder of the right of habitation to rebuild or repair the building. This judgment was, however, widely criticized. And then there's just an activity. And then number 8, relationship between servitude holder and owner of burdened thing. The rights of the servitude holder enjoy precedence over those of the owner, insofar as the exercise of the servitude is concerned. He or she is entitled to perform all the acts that are necessary for the due exercise of the servitude. This should take place in a reasonable manner, civiliter modo, with the least possible inconvenience to the owner. On the other hand, the owner of the servient tenement is entitled to exercise his or her rights as owner as long as these do not conflict with the servitude holder's rights. And then there's another activity, and then we go on to number 9. The following remedies are available to a servitude holder. Number 1. The actio confessoria is a real remedy available to a holder of a servitude by means of which he or she can prohibit impediment or limitation of the reasonable exercise of his or her servitude entitlements by means of a court order. The servitude holder can also claim compensation with this action. Number 2. The actio negatoria is an action available to an owner against the holder of a servitude who exceeds his or her servitude entitlements, and also against any other person who wrongfully claims servitude entitlements. Number 3, an interdict. Number 4, a declaratory order. Number 5, a spoliation order. If the servitude holder's control over the thing is disturbed in an unlawful manner, he or she can restore his or her control with the spoliation order. And lastly, the Aquilian action. And then there's a small activity, after which we can move on to number 10, public servitudes. Certain rights referred to traditionally as public servitudes are established for the benefit of the general public. For example, the right of outspan and commonage. This is not a land servitude, as there is no dominant tenement, nor is it a personal servitude, since the right is not vested in a particular person. It cannot be acquired through prescription, and it does not lapse through non-use. It is therefore questionable whether this right can be really classified as a servitude at all. And then there's just an activity, after which we move on to restrictive conditions. Number 1, introduction. This study unit refers briefly to restrictive conditions. Restrictive conditions are a group of limitations on ownership, comprising such limitations as conditions of title, town planning conditions, conditions imposed on the subdivision of stands, restrictive covenants, etc. Restrictive conditions can be defined as a category of limitations on ownership, which are: number 1, either registered against the title deed of property or not so registered, and number 2, imposed in terms of a statute or based on a contract, and number 3, in the interest of land use planning. Although restrictive conditions as a group are not necessarily classified as limited real rights, some restrictive conditions can be classified as limited real rights. For the purposes of this module, we concentrate only on conditions of the title because these are a category of limited real rights. Conditions of title can be defined as limited real rights inserted into title deeds of property, either in terms of legislation or as a result of a contract to regulate land use. Number 2. Remedies. Remedies available in the case of non-compliance with conditions of title include: number 1, an interdict, and number 2, a quillian intellectual claim for damages. Conditions of title may be removed or modified in a variety of ways, including: number 1, by court order, and number 2, in terms of certain statutes, for example, the Spatial Planning and Land Use Management Act number 16 of 2013. And then there's just a small activity.